So, good afternoon, class. As I have mentioned last week during our meeting, our review on the answers that you have during our pre-test exam, I will not be available today. However, I have pre-recorded my discussion so you can view it at any time that you are available. And please take note of all the important details that I am about to discuss because definitely by Wednesday, during our class on criminal law and jurisprudence, I will be asking some questions and we will have a recitation. So please take note of the important concepts that I will be discussing this afternoon because some of them actually affect the jurisdiction of our court. So, for everybody's information, no, diri tanan nga criminal acts are triable. What do we mean when we say triable? Diri karuyag signon nga tanan nga criminal acts performed by individuals pwede i-try or pwede i-kaso dinhi sa Philippines even if these violations violate Philippine laws. Kaya ano, because we have several characteristics of criminal law which also affect the jurisdiction of our courts. No? So we will be discussing that this afternoon. And again, I repeat, I hope that you will take note of the important provisions that I will be talking about. No, because we will be having a recitation on Wednesday. And if we have the time, I might probably give you a short quiz before we begin our class on Wednesday. So please be prepared for that. So ini naman nga akong discussion niya na is already pre-recorded. You can view this at any time, bisan makapera ka beses. So I think there will be no reason for you not to be able to answer the questions that I will be giving on Wednesday during our class. And also, I think everybody will not have an excuse again. Ano nga, what I load or whatsoever. Kaya you actually have at least 2 days no to watch the video. It's just good for 1 hour or maybe even less than 1 hour. So please take the time to study. I don't want what happened with our pre-test to happen again, especially nga may medyo hastayan na I still feel aggravated kay may adao sa lagi nga nagbutang no answer. It's a big no-no for me. Please do not do that again. If someone will commit that again, definitely I will fail you in this class because it only shows that you are not trying hard enough to be here and also to answer the questions that are being posted to you. So I cannot continue to tolerate that kind of actions, no, because it's unfair to the teacher that is preparing your exams. It's also unfair to all your other classmates who are taking the time to read the notes, who are taking the time to review, and who are doing their best to answer the questions that I'm giving. So if you do that again, whoever you are, then definitely you will fail this class. So it's my last warning for you. Okay, so anyway, going back to my discussion, I will now share my presentation. So today, our topic, as I have mentioned earlier, is very important because we will be discussing the characteristics of criminal law. So basically, there are three main characteristics of criminal law. It's generality, territoriality, and prospectivity. Okay, again, take note, generality, territoriality, and prospectivity. So we will be discussing those general characteristics during our class today. So I will be thoroughly discussing these concepts. So again, take note if ever I am mentioning important provisions. Okay? So we will start with generality. So criminal law is binding on all persons who live and sojourn in the Philippine territory. So karuyag singon, it Philippine criminal law diri lahiya applicable no? Diri lahiya applicable ha mga Filipino citizens because the law itself says that criminal law is binding on all persons who live or sojourn in the Philippines. So even if momentarily laan iya pagstay din niya Philippines, diri permanent. Parehohin mga turista, no? So, diri hira nag-iiha dinhi kay they are just here for a short visit. But even if so, bisan diri ra citizen of the Philippines, they are foreign tourists. If they violate our criminal laws, then they can be held liable here in the Philippines. Kay ano, kay an balaod, waray hiya magyakan nga Filipino citizens la. It pwede maging held liable for criminal law. Ang nakabutang nila, all persons, whether Filipino citizen or a foreigner nga naukoy or umagi nag-sojourn dinhi nag-travel in the Philippine territory can be held responsible for violation of criminal laws in the country. So Article 14 of the new Civil Code provides that penal laws and those of public security and safety shall be obligatory upon all who live and sojourn in Philippine territory, subject to principles of public international law and to treaty stipulations. However, no, there's a general rule and there's always an exemption. Ang general rule din no, when we apply this article, nga tanan nga klasihin tawo pwede maging held liable for a criminal offense or a felony in the Philippines even if they are a citizen or not. However, naghatag gihapon mga exemptions ang balaod mismo. Ini man din nga sentence nga nayakan nga subject to the principles of public international law and treaty stipulations. Ano't karuyog sigon hito? It karuyog sigon hito except no. Except this provision actually provides for an exemption to the law. So except if may ada public international law or treaty stipulation wherein some individuals are actually exempted from coverage of criminal law or exempted from liability. So ano ito? Again, utrohon natin no. The general rule is that tanan nga klasihin tawo whether a citizen of the Philippines or a foreigner may be held liable for criminal law if he or she commits an act or omission in violation of a law here in the Philippines. However, may ada ito tinatawag na mga exemptions. It mga exemptions usually natikang ha public international law or treaty stipulations. So amo po ito, no? So next, exemptions to the generality. Amo na ini. 'Di ba kanina nayakan kita except for if there are certain principles enshrined in public international law and treaty stipulations, no? So except ito, aadinan exemptions, no? So number one, basis agreement between the US and the Philippines. So actually before the Philippines entered into a visiting forces agreement, no, with the United States of America. So hanuna, if you can still remember, may kita mga US bases, no, dinhi ha Philippines. Most of them actually were in Pampanga, no, in Clark, Pampanga. So ito dida nga agreement, this is actually a treaty no, or an agreement between the US and the Philippines. Ito dida nga agreement, ang nakabutang dida, the Philippines consents that the United States have the right to exercise jurisdiction over the following offenses. Kay ano, kay kung waray ini nga agreement, generally, ini nga mga offenses nga naka-enumerate dinhi, haaton unta courts, ha aton local courts or domestic courts igta-try or igkakaso. However, because of the agreement or the treaty stipulation, he Philippines iya gintugutan nga ang United States ang magkakamay-ada right no to adjudicate or exercise jurisdiction. Siguro yan na maaram naman kita karuyag signon hit jurisdiction na no. Diba? The right to try a case, that's jurisdiction. No? So, for example, any offense committed by any person within any base except where the offender and the offended party are both Philippine citizens, not members of the armed forces of the United States on active duty, or the offense is against the security of the Philippines. So for example, ito sa nga American soldier, no? Nakapatay hiyahin hin either Filipino soldier or nakapatay hiyahin iaig kasi US soldier, um, puwedeng nga ang United States an magkaputhan kaso. Diri ang Philippine courts ang makaputhan kaso, no? So kay ang nakabutang man din especially if an ito nga commission or an act was made inside the base, the US Army base, kundi inhera may ada base. No, so as I mentioned, normally ang dami nin mga bases actually were in Clark. I don't know in Mindanao area, but ang akong maaraman ada Clark, Pampanga or Hasubik, Pampanga. So ito. So for example, itong scenario usa nga US officer or US Army nakapatay hiyan ig kasi US Army or Filipino didto hasulodhan base or han base, pwede hiya ig-try or makasuhan dinhi didto ha United States, no? Ikaduha, any offense committed outside the bases by any member of the armed forces of the United States in which the offended party is also a member of the armed forces of the United States. So ito again. So bisan man hagawas hiyahan basehan base, no, hanira ditohan base. So bisan man hagawas na commit an crime, but it's also against hakapwa niya US Army, then again the case, for example if it's homicide or murder, the case will not be tried in the Philippines but in the US courts. Okay? Ikatulo, any offense committed outside the bases by any member of the armed forces of the United States against the security of the United States. So kanina kasi no nakabutang man didi against the Philippines kay kung security against the Philippines ito, then dapat igta-try ang kaso ha Philippines. But here bisan outside ha base, no, outside ha base han US Army din na Philippines ging commit an crime, if it is against the security of the United States, then the US courts will have jurisdiction. So ang kaso adto hihimuon ha US courts. Okay, next. So we also have other treaties. Amo na yun akong gin-mention kanina nga visiting forces agreement. So US military authorities shall have the right to exercise within the Philippines all criminal and disciplinary jurisdiction conferred on them by the military law of the US over US personnel in RP. So nga iniliwat nga visiting forces agreement nga tanan nga US military men and women will be under the jurisdiction of the United States and not the Philippines. US authorities exercise exclusive jurisdiction over US personnel with respect to offenses, including offenses relating to the security of the US, punishable under the law of the US but not under the laws of the Republic of the Philippines. So ini naman liwat again ginutrula, if it's relating to the security of the United States, then it will be tried in the US, no? US military authorities shall have the primary right to exercise jurisdiction over US personnel subject to the military law of the US in relation to number one, offenses solely against the property or security of the US or offenses solely against the property or person of US personnel. So again, kanan mga US properties nga aadahan base or property mga visiting forces. Kay kind of visiting forces kay nakanhi adto hera, di ba? Nagbisita hera ha Philippines kay nagkakamay ada hera hin training para mga Philippine military personnel. And number two, offenses arising out or any act or omission done in the performance of official duty. So kung nakakommit herahin crime, nagpe-perform herahan era duty, for example, no, usa nga police officer nakaligis hiya hin bata while driving a vehicle of the United States, and iya pag-drive apihan iya official function sigun natin nga driver talaga hiya hadto, but while performing an iya official obligation as military personnel, then nakaligisiyahan bata, even if the child is Filipino, that will still be tried under the United States and not the Philippines. Okay? Kaya an iya act or omission was done, the criminal act or the criminal omission was done in the performance or in relation to his official obligations under the visiting forces agreement. So adiliwat, ibaliwat inihiya nga laws of preferential application. May kita kasi mga ginsusunod gihapon nga mga international laws, no, din Philippines nga may gihapon mga certain individuals who are exempt from jurisdiction of the Philippine court. So Republic Act number 75. So this is a law here in the Philippines, may be considered a law of preferential application in favor of diplomatic representatives and their domestic servants. So mara makamot mga diplomatic representatives an aton mga ambassadors nga aadto ha ibang bansa nga nagre-represent ha aton. For example, ambassador to the Philippines in the US, ambassador to the Philippines in Japan. So iba-iba tong mga ambassador. So they are diplomatic representatives. So itera kasi to purpose kung kaano tera bansa ha ibang bansa is to maintain diplomatic relations. So ano't nakabutang hininga Republic Act? Ibaliwat iniya, ibaan basis agreement between the US and the Philippines, ibaan visiting forces agreement, iniliwat laws of preferential application, no? So section 4 of Republic Act number 75, any writ or process issued out or prosecuted by any person in any court of the Republic of the Philippines or by any judge or justice whereby the person of any ambassador or public minister of any foreign state authorized and received as such by the president or any domestic or domestic servant of any such ambassador or minister is arrested or imprisoned or his goods or chattels are distrained, seized or attached shall be deemed, and every person by whom the same is obtained or prosecuted, whether as party or as attorney, and every officer concerning in executing it, shall upon conviction be punished by imprisonment for not more than 3 years and a fine of not exceeding 200 pesos in the discretion of the court. So, Section 5 liwat, the provisions of Section 4 hereof shall not apply to any case where the person against whom the process is issued is a citizen or inhabitant of the republic of the country in the service of an ambassador or public minister, and the process is founded upon a debt contracted before he entered upon such service. Nor shall the said section apply to any case where the person against whom the process is issued is a domestic servant. So, kabulig, no? Of an ambassador, kabulig an ambassador or a public minister, unless the name of the servant has before the issuing thereof been registered in the Department of Foreign Affairs and transmitted by the Secretary of Foreign Affairs to the Chief of Police of the City of Manila, who shall upon receipt thereof post the same in some public place in his office. All persons shall have resort to the list of names so posted in the office of the chief of police and may take copies without fee. So ano man it karuyag sinyon hini, adi na. So the following are not subject to the operation of our criminal laws based hini nga Republic Act number 75, no? Number 1, sovereigns and other chiefs of state. So hinuman hera president, an aton kun hera prime minister or kung may dehera king or queen or any head of state. Ikaduha, ambassadors, ministers, plenipotentiary, ministers resident, and charge the affairs. So, amer mga exempted. Take note ha, even if they commit a criminal act here in the Philippines, they are exempted from the operation of our criminal laws. So, diri hira pwede igtry, diri hira pwede kasuhan dinhi haaton, no haaton mga korte. Kay ano, because it is the law itself that provides for such exemption. Imagine, no? This is a very interesting law. May ada ngayon mga tao ano nga exempted talaga. So, yun. It is well-established principle of international law that diplomatic representatives such as ambassadors or public ministers and their official retinue possess immunity from the criminal jurisdiction of the country of their sojourn and cannot be sued, arrested, or punished by the law of that country. So ami tong karagsigman hinin halalaba nga nga mga provisions of the law, no? In conclusion, inihira nga sovereigns, head of state, chief of state, hinabat hera president, no? The president is immune from suit, no? So for example, an US president kung man hindi na Philippines nag-commit hiyahing crime, then he cannot be sued here in the Philippines even if the crime is against a Filipino citizen because he is beyond the operation of our criminal laws. Diri hiya covered hit aton criminal laws. So imagine the laws no of the countries. But it is an established international policy and international law para ma-maintain gihapon it diplomatic relations it mga bansa. Kaya ano, for example, makanhi an President United States, no, na komite for example, again, nakaligis hiya hin Pilipino, tapos kakasuhan hiya, pwede ito magkosinggera. Kung presuhon natin it President it ibang bansa din hiya aton country. That's why to maintain the diplomatic and peaceful relations of nations and mga heads of states including the ambassadors, ministers plenipotentiary, ministers resident and charge the affairs are actually exempt from the operation of criminal laws here in the Philippines. Then it is a highly regarded principle of public international law. Dito basta-basta pwede barion kay bangin magkus itohin world war, no? So, pero liwat, no? A consul is not entitled to the privileges and immunities of an ambassador or minister. So, take note laliwat nga may adala naka-specify dida kung hindi ito nga mga persons immune from suit. Diri dida api and consul. So, it is well settled that the consul is not entitled to the privileges and immunities of an ambassador or minister but is subject to the laws and regulations of the country to which he is accredited. No? In the absence of a treaty to the contrary, a consul is not exempt from criminal prosecution for violations of the law of the country where he resides. Consuls, vice consuls, and other commercial representatives of foreign nations do not possess the status of and cannot claim the privileges and immunities accorded to ambassadors or ministers. So again ha, ang consul, no, take note, they are not covered by the immunity. So kung hera mag-commit crime while they are accredited here in the Philippines, karag singo na adira Philippines, hinaban nga mga consul. These consuls are actually, some of them, all of them are employees of the uh, of the country to which they are citizens, and they are deployed to another country para liwat hirata ato dito ka embassy. No, so ito, hirat nagpa-process it mga visa, ito, mga tourist visa, kung ano pa man ito nga mga visa. So itera iton function is more on commercial, no? Diri na hiya more on diplomatic relations. Diri hiraan hidinhi ha Pilipinas para mag-maintain hin diplomatic relations. But aanira din ha Philippines. Kaya may ito nga, may da mga administrative concerns such as the issuance of visa or certificate of visitation, mga saga dito. Okay? So again, a consul is not entitled to the privileges and immunities of an ambassador or ministers. Okay, so we are not now done with generality. So as a review, no, the general principle is that criminal law is binding on all persons who live and sojourn in the Philippines. So ano constitute of generality? So dapat it is general to all. It should be applicable to all except for certain exemptions. So syempre may ada exemption. So the general rule, criminal rule, should be general in nature and should be applicable to all except for certain exemptions such as the USRP or US and the Republic of the Philippines basis agreement, the visiting forces agreement, laws of preferential application, no, and Republic Act number 75, no, and other principles of international law. So we are now done with generality. Now let's go to territoriality. So territoriality provides that criminal laws undertake to punish crimes committed within the Philippine territory. The principle of territoriality means that as a rule, penal laws of the Philippines are enforceable only within its territory. So the general rule here, when it comes to territoriality, dapat an crime or felony should have been committed inside the Philippines, 'di ba? Again, dapat an crime committed should have been here inside the Philippines. That's why kung Filipino citizen ka nga nangawat ka ha United kumadto ka na ha United States, for example turista ka dito ha US, no, nangawat ka didto, dili ka pwede kasuhan hin theft dinhi ha Philippines. Kaya di mo commission or omission didto man ha US. So didto ko it may jurisdiction hito dida is the United States of America. So extent of Philippine territory for purposes of criminal law, no? So again, adi naluwat kita. Maya the general rule. Now, the general rule is this one. Ang meaning nga adi didi. Number one, criminal laws undertake to punish criminal crimes committed within Philippine territory. But again, we have exemptions. Permit to may the exemptions to the rule. No? So, Article 2 of the Revised Penal Code provides that the provision of said code shall be enforced within the Philippine archipelago, including its atmosphere, its interior waters, and maritime zone. Article 1 of the 1987 Constitution provides that the national territory comprises the Philippine archipelago with all the islands and waters embraced therein and all other territories over which the Philippines has sovereignty or jurisdiction consisting of its terrestrial, fluvial, and aerial domains including its territorial sea, the seabed, the subsoil, the insular shelves, and other submarine areas. The water around, between, and connecting the islands of the archipelago, regardless of their breadth and dimensions, form part of the internal waters of the Philippines. So, this is a very important definition of Philippine territory. Added to aton Article 1 of the Philippine Constitution, what are the metes and bounds of the Philippine territory? It api. So, imagine, no, pati it kalangitan, that is part of the Philippine territory, and no aircraft could pass through our our aerial domains without without the approval of our government, no? So yun. So exceptions, dinaluwas kita ng exemption. So again ha, I am repeating this again because this is a very important concept. The general rule, criminal laws undertake to punish crimes committed within Philippine territory. Pero we also have exemptions to the territorial application. Sige daw, ano ni nga mga exemptions? Dito Article 2. The Article 2 of the Revised Penal Code provides that its provision shall be enforced outside of the jurisdiction of the Philippines against those who. So, adi na. Ang first statement, Article 2, Revised Penal Code provides that the provisions of said code shall be enforced within the Philippine archipelago, including its atmosphere, its interior waters, and maritime zone. However, the second paragraph of that article provides that its provision shall be enforced outside of the jurisdiction of the Philippines against those who. So adi na, pwede nga yung gumawa sa bisan dirigin commit din hiha Philippines, pwede gihapon magkaadahin jurisdiction or right to try the case an aton country and aton domestic courts and aton regional trial court or an aton municipal trial court kung ini nga mga violations ig-commit hit usa nga tawo, no? Siyahan should commit an offense while on a Philippine ship or airship. So ini hira mga eroplano, no, or barko. So if they are flag bearers, vessels, no, for example may barko nga ginrehistro din niya Philippines tapos naglalayag na hiya nakadto na hiya Atlantic Ocean then nagkamay-adahin piracy may nagkasaka nga mga pirate hito nga barko then because of that may ada mga nagkamatay nga mga tripulante. So because the ship is a Philippine ship, bisan pa ang piracy was committed in the high seas. Take note ha, walay tag-iyat high seas. Walay ito nagtatag-iyat mga it high seas. Kung ano ito for everyone ito pwede gumamit ito dito. Ito kadagatan, kahaladman. No? So, bisan pa nakatunera high seas or even nakatunera outside han territory han Philippines, kay ang ship nga gin-pirate, ang ginsakan han mga pirates, kay Philippine airship man, ito nga mga pirates pwede hira kasuhan din ha Philippines or an era country where they are from pwede kasuhan. Okay? Ikaduha, should forge or counterfeit any coin or currency note of the Philippines or obligations and securities issued by the government of the Philippines. And I'm reminding you of this one ha, kay this is very important. May dapala na dako pwede nga TikTok. Kay actually, pag counterfeit hit money, no, diri, even if dito here, ginhimo ha ibang lugar like China, Taiwan, or whatsoever, tas ang money is Philippine currency. Karong sigon kwarta din nila Philippines. Regardless kung diin pa at hiya ginhimo, that can still be tried here in the Philippines. Kaya it involves Philippine currency and it is one of those cases where uh, bisan an omission or commission was made outside of the Philippines, pwede gihapon hiya try din hi. And please, ito nga ni nga mga tampering ni hit mga coins, ayaw niyo paggubag daw. Ayaw niyo pagtunawa mga coins, ayaw niyo pagsunuga, kwarta. Kaya because even if we have possession of the money, it's not ours. It always belongs to the Philippine government and there are certain sanctions on that. Bisan nga nit pagsusurat ha kwarta, diri gihapon ito pwede. Bisan nit pagpilo-pilo, overfolding to the point nga nakukunot na kwarta, may da ito mga penal sanctions pwede ito magkamay-ada ng criminal liability. So, yan na, gini-remind ko ka mo, never do that ha, kay may da ito yan na palagin dakop kay hayra TikTok. I don't know what they were thinking. Nagsunog hirahim 20 pesos. 20 pesos lang nga nito, but that's a big no-no under our laws. And what can we do? The law may be harsh. Even if it's only 20 pesos, the penal sanction is actually up to 12 years. Imagine, nagsunog ka lang 20 pesos, pwede ka ngayon maprisuhin 12 years. So I'd never do that, ha? Never tamper, never forge, never never destroy Philippine currency, no? Ikatulo, should be liable for acts connected with the introduction into the Philippines of the obligations and securities mentioned in the preceding number. So kung hino man ang nagdarahito dinhi ha Pilipinas nga mga counterfeit money, even if dirihiya siya ang naghimo, no, pwede gihapon hiya maging liable. Bisan hiya tikang ha ibang bansa. Ikaupat, while being public officers or employees should commit an offense in the uh, exercise of their functions. No, so ano man korek sigon hini. So again, kung may nakita mga officers ha ibang bansa, of course, exempted ang ambassador, di ba? Nakanumdum ka mo mga exemptions. Pero kanang mga ordinary employees like consul gihapon, didto ha ibang bansa, no? Ang aton Filipino consul ha ibang bansa nag-commit herahing crime in relation to their official function, even if they committed such crime outside of the Philippines, pwede gihapon hera i-try din ha Pilipinas, no? Should commit any of the crimes against national security of the law of nations defined in Title 1 of Book 2 or of the Revised Penal Code. So, security in the law of nations, for example, piracy, because piracy is a borderless crime. So, anywhere in the world, basta kung diin ito hiya, kung ha usa nga flag bearer nga ship hiya gin-commit it piracy. So, bisan pa siya dito na katuktukan hiton Antarctic, Arctic, Atlantic, kung ano pa man ito nga mga ocean harayon ng Dura, Filipinas, if it is committed against a Philippine airship, then it is still punishable in the Philippines. Okay, so that is the territorial um, applications. So again, ano to? One basic characteristic of criminal law is that territoriality. Ano the territoriality? General rule is that crimes are punishable if they are committed within Philippine territory. But there are certain exemptions. Anong exemptions? Ada Article 2 of the Revised Penal Code. Amo na ito na gin usa-usa kanina. 1 to 5 ito hera. So do not forget that. If you can take a picture of this one, because definitely I will ask this again during our recitation on Wednesday. Okay, now we are on the last leg of our characteristics of criminal law. Prospective. Ano't kareg signun hini? That a penal law cannot make an act punishable in a manner in which it was not punishable when committed. So if you still remember your ex post facto law, no, nga makes an act criminal that during the time that it was committed, it was not actually defined in a certain criminal law. So dapat permit waray retroactive at karag signon, waray retroactive application. Permila at hiya prospective anat karag singon retroactive. Again, no, for example, an usa nga act is not punishable under any specific law, pero suddenly may ada law nga gin-enact and aton legislature nga and law will punish all acts committed from 50 years ago. Dirito pwede. Kaya di ba, ex post facto law hiya. So the general rule is that laws should always be prospective. So will apply from today and then onwards, never backwards. No? However, again, there is an exemption. So, as provided in Article 366 of the Revised Penal Code, crimes are punished under the laws in force at the time of their commission. So, kung ano ang mga balaod, hadto nga time, no, amo lang applicable. Kung wala balaod nga nagpa-punish ito nga act, then that act cannot be punishable. No, diri ito sa nga tao nga nag-commit han act, pero diri man hiya defined in a criminal law, specific criminal or penal law, dili hiya pwede kasuhan. Kay ano matig kakasuha iya? Kay waray man crime in the first place. Kay waray man criminal law nga na-punish ito nga act. No, for example, before wala kita tinatawag nga um, VAUSI. 'Di ba? Wala kita violence against women and children. So, ang mga victims sa VAUSI, ano ra to usually ginfa-file is physical injuries, no? So, diri hiya VAUSI. So ang VAUSI liwat diri pwede mag-apply han mga previous nga mga cases kay prospectivity hiya. From the time la kung kakano enact onwards na an application. So backwards, what are filing hin? VAUSI. Okay, so exemptions now. Amo ito't paborito ang mga balawdan. Okay, pero may mga exemptions. Makuri na nga ni pagmemorya ang general rule. May da pa ngayon exemptions gihapon. No, so, exemptions to prospective application. Whenever a new statute dealing with crime establishes condition more lenient and or favorable to the accused, it can be given retroactive effect. So imagine this rule, no? It's very, very, it's very, it's always for the accused talaga. No, when we talk about criminal law, when we talk about rights, constitutional provision, it's always for the rights of the accused, no? Whenever a new statute dealing with crime establishes conditions more lenient or favorable to the accused, it can be given a retroactive effect. Ano man karayag signal hito? For example, may ada kita murder case, no? Murder case. So murder case, punishable ito by reclusion perpetua. So reclusion perpetua, pag reclusion perpetua kasi iton iton kaso diri kita basta-basta pwede mag-post in bail. 'Di ba? Kay it's a matter of discretion of the court. So depende ha court kung susugtan kita nira mag-post in bail. And then suddenly example lang ni ha this is not diri ni law yan na. I'm just stating this as an example. For example, onwards nagkamay adahin balaod nga itong reclusion perpetua nga mga cases pwede na mag-post in bail anytime. Diri na hiya discretionary ha court pananglitan la ha. For example ha direct na ka nga may ada na hini nga balaod. But just in case in the future magka may ada hin sugad hini nga balaod, pwede tiya retroactive application. So may ada mga murder cases from before of the effectivity of the new law nga allowing bail even if uh, crimes punishable hiya by preclusion perpetua, applicable hiya backwards. Pwede apply han maging kasuhan previously for murder. No? So amo ito tinatawag na lenient or more favorable to the accused. Kung ano mas makakagaan para hit accused, pwede hiya tagaan hin retroactive effect. Pero kung unfavorable hiya para hat accused, wala ito retroactive effect. Always prospective it iya. Kung for example, ang reclusion and instead nga reclusion perpetua himuon nga death sentence na so prospective na ito. Ang mga may kaso before hin murder, iga-apply ha ira is still reclusion perpetua. Diri iga-apply ha ira that that sentence, no? So that is an example of that. But again, there is an exemption to the exemption where the new law is expressly made inapplicable to pending action or existing causes of action. So for example, ang bago nga balaod, hiya mismo dito ha iya provision sa iya stipulations, may ada mismo nakabutang nga hindi nga balaod ma-apply lahiya ha yana or diri hiya ma-apply ha mga pending nga mga cases. Ma-apply lahiya han mga mahihimo pa lang ang mga case, no? So pwede ito mismo ang balaod dan magbutang nga diri hiya waray hiya retroactive effect. Ikaduha, where the offender is a habitual criminal. So, habitual punished for the same crime twice under the same title. So, for example, bisan pa ito hiya favorable to the accused, pero hiya accused kada mo na makapatay hin tawo, diri na ito ay ga-apply kay habitual na hiya, permi-permi na lahiya naghihimo hito nga mga sala or nga mga crime. So again, that is an exemption to the rule again, no? So uh, the general rule on prospectivity dapat onwards la permi forward. Always moving forward it aton laws. But if it is more lenient to the accused, then it could be given retroactive effect, except if the law itself makes it does makes it prospective. Ang law mismo ang nag-declare nga diri pwede retroactive application or if the offender is a habitual criminal. Okay? So, different effects of repeal of penal law. If the repeal makes the penalty lighter in the new law shall be applied. Man o kung mas habubo na ang penalty, then the new law will be applied. Except when the offender is a habitual delinquent. Again, utro-utro lang ito niya ginhimo nga mga crimes. Or when the new law is made not applicable to pending actions. So, amo na ito natin exemptions nga state kanina. Ikaduha, if the new law imposes a heavier penalty, the law enforced at the time of the commission of the offense shall be applied. Again, if this is not lenient to the accused or it is not favorable to the accused, then it cannot be given retroactive effect. If the new law totally repeals the existing law so that the act which was penalized under the old law is no longer punishable, the crime is obliterated. Imagine, no, for example, kung diri na ngayon, for example, BP22, issue one sin bouncing check. Ano't bouncing check? Bouncing check is naghimo ka hin cheque, nag-endorse ka hin cheque, pero ito nga cheque, wala ngayon pundo dito ang bangko. Tapos pagkadto ito nga imo gin-endorsean ng cheque, ma-claim na hiyahan funds, wala ngayon pundo, then that's considered BP crime punishable under BP22 or the bouncing check law. Pero what if mag-enact hin law repealing? Diya ka nga oy diri na ni punishable hin crime kay kuan man la ito. Ano pa? Dili man talaga heinous, no? Dili man hiya vile, no? So tanggalon ta na lang ni nga BP22 barak magyakan ha eh. Klarohon ko la direk nagyayakan nga tanggalon na ito. I'm just setting an example here. So for example, in the future nagkamay adahin hin balaod nga waray na BP22 i-repeal ta nala, the crime is obliterated. So if may ada persons nga accused for that BP22 while ongoing in trial, pwede, pag gumawa ito nga bago nga balaod, pwede hiya ma-acquit, i-obliterate, madi-destroy, waray na kaso. No, kay may na bago nga balaod, nga diri naging kicriminalize ang BP22. That is, if may ada na balaod, waray pa hahastaya na criminal offense lagi hapon or crime lagi hapon, it pag issuehin cheque nga waray pondo. Okay. So that ends our part 3 of our discussion on characteristics of criminal law. So generality, as a review had generality, territoriality, and prospectivity. So I hope you understand the basic concepts that I taught you today. No, so please continue to review the discussions that I have stated today. Kai, we will have either a quiz or a recitation on Wednesday. No, so I would require you to do a recitation or a quiz on Wednesday. So please review. If you have the time, mas mabay kung kadamon niyo kitaon ini nga akon presentation. This will be posted on YouTube or this is already posted on YouTube so you can view this anytime, no, at your own convenience, but just make sure that you are ready for recitation by Wednesday. So that's it for today. I hope you learned something from my discussion. Next week we will be discussing part 4, construction of penal laws. So how does the courts of the Philippines construct or interpret the laws or criminal laws? So yan na masasabtan na naton ini nga mga concepts. Papunta pa lamang tayo sa exciting na part, no? So it's becoming more and more exciting, and as we go along, damo pat aton maaad man. Just please listen to what I am telling you and take time. No, take the time to read the discussions. Take the time to read the notes that I am giving you because I will not give you questions that are not discussed or not given in the review notes. So anyway, that's it for today. I hope that you will always be safe and healthy wherever you are. So for the meantime, no, just study and take down notes from the presentation that I have given you, and I'll see you on Wednesday. So bye for now. God bless to everyone and keep safe.